thank you everybody for coming along and joining us. We're going to have a discussion tonight about the use of intermediaries and advocates in the family courts. We hope the point of it is to be of practical help to us all, really making sure we get our clients the most from these services and making sure that we all understand them and the differences between them. For those who don't know me, I'm Alexandra Davey. I'm a barrister here at 5 St Andrews Hill on the family team. I'm also joined by Heidi Burrows, who is a fellow barrister here in Chambers. We both work on the full spectrum of family law cases, public and private children proceedings, domestic abuse and other injunctive proceedings, and also financial remedies. I'm grateful to Heidi for her help in preparation for today, and also to Tess, who's next door, for organising us all this evening. We are joined by our esteemed panel too. We have Sasha Lee from Dawson, Cornwall. Sasha specialises exclusively in private and public children law cases, especially those with international elements. She helps parents reach arrangements for their children after separation, including in respect of international contact, international relocations, child abduction, both Hague and non-Hague, recognition and enforcement of foreign orders, international adoptions, domestic abuse, and cases involving serious allegations. We have Danielle Marin, who is from Triangle. She's their intermediary training manager. She has a background in psychology and experience as a lecturer. She's been an intermediary with Triangle for 9 years, and she has experience in working with a wide range of vulnerabilities and age groups, both family and criminal court based. She's now focused on training and mentoring new intermediaries and supporting the wider team at Triangle. We have Kat Edwards, who is the advocate and manager at the Elfrida Society. She's been the head of services there for over 3 years, and she oversees Care Act, health and community advocacy projects, as well as consultation work with supported employees with learning disabilities. The project has doubled in size during Kat's tenure there, and she now supports parents in 15 London boroughs as well as further afield. She's been an advocate for people with learning disabilities for over 20 years, and also a teacher for foster carers and adults with learning disabilities throughout that time. Our plan is to hear from Sasha in relation to the legal framework that applies to intermediaries and advocates. Then we'll ask Danielle to tell us about the intermediary side of things, then on to Kat to tell us about the role of advocates, and then we're going to have a look through the chat box. So please, as we go along, do put any queries, questions or comments in that chat box at the bottom, and we'll discuss those in the time that we hope we will have remaining at the end. So without any further ado, I will hand over, thankfully, to Sasha.
Hi, and thank you so much for having me. This is such a good topic to talk about, and something that is, I think, and positively so, gaining increasing traction in our family law world, and something that I think we should all be really familiar with and kind of have a good working knowledge of. I'm afraid we're almost starting with the more boring technical part first. I will try not to make this terribly dull. The good news is that the rules on intermediaries are actually quite narrow, but as we'll kind of go through, the way it's been interpreted has changed a little bit, but we have just had a very helpful judgment come out recently, which in effect summarises the proper approach that should be taken. Some might say clear as mud, but actually I think if one digs down into it a little bit, I think there's a lot of really useful nuggets in there that we can all apply in our own practices. So the initial kind of starting point, as the almost sort of lecturing point really, is all practitioners who work in this kind of area of family law would be well advised in familiarising themselves with both the Advocates Gateway and in particular sort of Toolkit 13, because that relates to vulnerable witnesses in the family court. And I think as solicitors, it's tempting perhaps to think that maybe we don't need to consider this so much if we're not doing the advocacy ourselves. But I think what is really helpful with this is it starts to give an idea about the sorts of ways we can engage with vulnerable witnesses, and giving us some hints about when we might need to start thinking about the topic of an intermediary and whether we think an application might be needed. Because as looking through that list, if you think that your client might not be able to give their best evidence, even with those kind of toolkits in motion, then it might be time to start thinking about whether actually we need to level up and also consider an intermediary. So Part 3A of the family procedurals sets out what the court's duty is and the key questions that we need to ask ourselves. So the court has a duty to consider the vulnerability of parties and witnesses and to consider how a party can participate in the proceedings and how a party or witness could give evidence. Now, I think we're all quite familiar with this when it comes to, for example, special measures where there are victims of domestic abuse and avoiding direct cross-examination in that way or screens in court. But this also applies to the use of intermediaries. And the court has a duty and a question. The key questions are whether a party's witness's ability to participate is diminished by vulnerability and whether their ability to give evidence is diminished by vulnerability. And it's important that those two questions are separated out because when seeking the instruction of an intermediary, it might be that they're instructed for the purposes of a hearing and to help a client or witness give their evidence, but it also might be for particularly vulnerable witnesses or parties that intermediary might need to be instructed for the proceedings and part of the proceedings, for example, to assist with conferences or solicitor meetings, for example, when putting together their evidence to even submit to the court. And so it's quite important that as practitioners, we kind of keep those questions in the back of our mind at all stages when we're engaging with a client who we think is quite vulnerable, and consider whether those questions perhaps need addressing by way of an intermediary. The court has also been quite clear that an intermediary is not an expert within Part 25. So it's not, when you're making an application for an intermediary, it's not that you need to put together a Part 25 expert assessment with 3 different inquiries and a summary document, a letter of instruction, a draft order. It's not that kind of an application. It's an application under Part 18 of the FPR, which is a C2 in lay terms. And you will basically need to demonstrate in this application that it is necessary for the appointment of an intermediary to enable the party to participate in the proceedings fairly. And it's this question of necessary and demonstrating whether it's necessary that has sort of caused, I think, a little bit of mixed judicial interpretation. The good news is I can come to you with there is now a settled conclusion on it. But it is that straightforward test of necessity without gloss. The court is also quite clear that you have to ask for permission for an intermediary. It's not something that you as a solicitor could decide unilaterally, and you can't engage one, as it were, sort of on your own and say to the court, look, we've gone ahead and done this. It is something that the court has to give permission for. So if you are concerned that your client is vulnerable and there might be some key hearings coming up or some key evidence coming up that they're going to need to set down by way of a statement, for example, this is the sort of application that you might want to be thinking about quite early on or as far in advance as you can. And it might be that you need to have an urgent hearing to consider this issue. For example, if your client suddenly has increased vulnerability and you've got fact finding coming up in a few weeks, it might be that you need to sort of apply urgently for a directions hearing to consider this, because you wouldn't want to get to fact finding or final hearing and it not be effective and cause a really distressing incident for your client in that moment, or you get to that and actually your client just gives evidence that might not have been their best. And so either you're looking directly at an appeal, or if it stands, it's sort of justice hasn't been done. We're all quite conscious of that. So when considering whether it's necessary, we did previously have some cases which from sort of 2012 to 2020, where the court took Part 3A at face value. And it was 3 different sets of appeals about whether an intermediary should have been extracted. And the court said, you just need to determine whether it is necessary to enable someone to participate in proceedings. And that was just the test. But I think the court then latterly got a little bit more concerned that maybe this might open sort of floodgates for an intermediary in every single hearing. And there were 3 cases that followed. One was West Northamptonshire against KA. And Mrs. Justice Leven, in fairness, didn't have either Part 3A or Practice Direction 3AA put before her on any, it seems, So she wasn't actually directed to the correct law, but she sought to apply a criminal case from the Court of Appeal and said that actually, when considering necessity, it would be exceptionally rare for an intermediary to be appointed. And there should be compelling reasons to do so. And there was a further case in 2024 called X and Y, where again the judge construed the test of necessity to be very, very narrow. So they said that actually only towards the far end of the spectrum will there be the cases where an intermediary is necessary, and very rarely for an intermediary to give instructions in advance of a hearing. And the third case was Oxford local authority against a mother, and they commented on this case of X and Y and said that actually I agree it will be critical as well for an intermediary to be given an expert report, which sort of supports their findings as to whether an intermediary is going to be necessary. So that almost suggested that actually we needed some kind of cognitive assessment before any application for an intermediary would be plausible. However, luckily in the Court of Appeal, kind of drawing together these three cases, in the case of Re-M, Lord Justice Peter Jackson actually said, I think we've overcomplicated all of this. And he disapproved of the above three cases, and in quite strong terms, it's quite a firm judgment. He was very clear that the case of the criminal case that Mrs. Justice Stephen had relied on, and in fairness to her, had been referred to, he said, I don't consider that to be an aid to the interpretation of Part 3A. He said that actually Part 3A is the product of the Vulnerable Witness and Children Working Group, and that is the basis on which Part 3A was drafted, and its relevance to the criminal proceedings, there isn't. He also said at paragraph 41 that we don't need to put gloss on what the test of necessity is. He said there's no warrant for overlaying it with concepts of rarity, exceptionality, or frequency. He said actually this just encourages the court to short circuit its consideration of the evidence in the individual case. And actually it's a projection. And what we should all be doing, and what judges should be doing, is simply applying the rules straightforwardly. And I know we all got sent the public law outline practice note with guidance from the President on the 28th of November, which, in fairness, referred to those prior three cases as they were the most current law at the time. And Lord Justice Peter Jackson basically just pointed this out and said those paragraphs within it, which are 36 to 37, they are now out of date, and that we just need a straightforward test of necessity. And the use of the intermediaries, lay advocates and cognitive assessments guidance from the President in January 2025, where it had guidance at paragraphs 16 and 17. Again, he said, that is now out of date. So you don't have to have a cognitive assessment before an intermediary, you make an application for an intermediary. Sometimes clients just become very vulnerable overnight almost. But clearly, if you've got one within your proceedings, that might be quite helpful for boosting your application. And when you're setting out your evidence to say, well, this is why we think it's needed, it is just the test of necessity. So I think some people might maybe say, well, we need some help with working that out. But I think it's not a Part 25 application, but considering those sorts of considerations when you're applying. So, when you're setting out why an expert might be needed, it's the same sort of idea when you're considering why an intermediary might be needed. There isn't complicated gloss on the same.
Thank you, Sasha, so much. Let's pass over to Danielle, who's going to tell us all about intermediaries.
Hello, good evening. Thank you so much for inviting me to speak to you this evening. It's great to kind of get out there what actually being an intermediary is, and what that's like, and hopefully we'll be able to answer some questions at the end of the presentation. I'm going to give you a bit of a sort of whistle stop really tour as to what an intermediary does and what that assessment might look like. So we'll move on. So in terms of who intermediaries are, intermediaries come from a range of backgrounds. They generally come from the list that you can see there: speech and language therapists, and sort of psychological and mental health professionals probably make up the majority of intermediaries. But what comes alongside that is intermediaries have to go through some additional training to gain those skills that are required to work in the justice system. So at Triangle, the organisation that I work for, we have a quite intensive training programme for our intermediaries. They do an initial 5 days with us, and then it's a pass or fail, and there's lots of assessments they've got to do to pass or fail to then come on board with us as intermediaries. Our intermediaries all enter into a 6-month probationary period where they spend lots of time out working with experienced intermediaries to gain those skills that they need and to get a full understanding of what it's like being in a court and how they can assist the people that we are working with. So it's quite a process that people sign up for, and they bring to it, like I say, lots of different life skills, lots of different experiences, but can only move forward if they pass that intermediary specific training as well. Next slide. So the primary function of an intermediary is to facilitate communication between the party and the court, and it's about improving that participation element that Sasha spoke about. It's those 2 elements. It's the participation, but it's also that giving of evidence. And our duty is to the court. We are impartial in everything that we do, and that duty remains with the court. But it's really important that as intermediaries, when we go and assess and we're working with young people and vulnerable people, that we are looking at it from those 2 perspectives. How are they going to participate throughout the hearing, but also very sort of focused on how are they going to manage when it comes to giving evidence. Next slide. So that's just a kind of a visual in terms of the timeline of an intermediary involvement and what happens and how that happens. So that initial referral will come into us as an organisation from the solicitor, and we would expect that we would get those expert reports that if they're available, that come before us. And what we do is we use them as a way to inform our assessment, really, and to think about what we might need to do at assessment and the things that we might need to look out for. What we always try and do as well is to get a chat with the referring solicitor to get an understanding of their difficulties with that vulnerable person and what it is that they might need some assistance with. We then move on to the assessment, and I'll talk a little bit more about what we do at assessment and the things that we're looking at on the next slide, I think it is. So we do that assessment, and then we send back a report that sort of lists what the difficulties are, but gives those recommendations, what we think needs to happen to enable that full and effective participation, and not just a passive party sitting there, not really being involved. That report, like I say, comes with recommendations, and that is then served to the court, which then generates hopefully a ground rules hearing to discuss what needs to happen if an intermediary is then granted. I've got to say, ground rules hearings take on very different paths depending on the court, but also depending on the level of recommendation and the vulnerability and the things that might be needed. So sometimes I've attended ground rules hearings, for example, that have been listed separately, and it's purely to discuss how we are going to manage the situation. I've also attended ground rules hearings that are the first, done on the first day of a fact find, and it's much more of a quick process. So it's very different depending on what it is that we need to chat about. And then obviously we are there during hearings, and I know, Sasha, you touched on, it's not just during hearings, it can be prior to any hearings, in conference with solicitor, right at the very beginning. It might be in conference with solicitor and barrister prior to the final hearing or whatever hearing it is that we're coming up to, and then obviously there's that assistance during the hearing. So when we write our report and when we do our assessment, not only are we looking at participation and evidence, we're also looking at when that participation and when we might be needed to assist that participation. And I've got to say, it's not very often that we do recommend that we need to be there prior to any hearings. And we make that judgment based on what we get from that person at assessment, but also based on the conversations that we've had with the solicitor and how they are managing those conferences. So that's kind of the timeline. So the actual role of the intermediary can sort of come into three sort of things. We do that communication assessment, and in that assessment we look at three main things. We look at what we call the foundations of communication, which is ultimately somebody's ability to concentrate, somebody's ability to follow information and to be present in that communication and in that interaction. We look at their expressive communication, which includes their ability to give a narrative, but also their ability to express themselves when they don't understand, and also to tell you if you have got something wrong, if you have misunderstood them. And then we look at their receptive communication, and that is, their understanding. But we look at that in different ways. We look at their understanding and their ability to take on board information and process information as a whole, but we also look at their very specific in terms of vocabulary and things in terms of how they understand what is being said to them. So that's the three key things that we look at in assessment, and we will report on those things and we'll make recommendations in relation to those things separately. So then when it comes to making those recommendations, we're covering things like how and from where evidence should be given, and not just evidence. I've personally made recommendations for participation to be from a remote location via a live link, because that's how that person was going to be able to participate effectively. We also look at recommendations around the timing and management of breaks, and talk about strategies to assist with effective participation. So what is the intermediary going to do that actually the court, the judge, the barristers, everybody who's going to be there anyway can't do? So we look at those specific strategies and make recommendations on how and what we are going to do. And almost sort of, sometimes people think this is actually the most important thing, but for me, in terms of participation, it's not. The whole type of question to ask is a very, very small part of our recommendations, albeit when we look at like the toolkits and things, it's the focus, and it seems to be the focus around the types of questions. That's only a very, very small part of what the intermediary is going to be looking at. So then when we get to court and we're actually assisting and we're facilitating communication, how do we do that? Well, the main way in which we do that is that we are providing that ongoing commentary to a vulnerable person in very simplified language in real time, to assist not only with their understanding, but with their ability to maintain focus and keep involved in the proceedings. If we've got a young person or vulnerable person who is not following what is going on, then they very, very quickly lose focus with that and they become disengaged from that. So if we can simplify that in a way that they can understand and can follow, there's much more likelihood that they are going to remain focused for longer. Other things that we will do is we will alert the court if we feel that there's a communication issue, and we will indicate the need for an unscheduled break. And then that rephrasing of questions in line with communication ability, and that is around more focus to when we're giving evidence and when we're in an evidence giving scenario. We do, prior to vulnerable people giving evidence, sometimes we will ask that we get questions beforehand, and that can be difficult because we are very aware that sometimes barristers, they don't know what they're going to ask actually until we've seen the evidence. So when we sort of ask for that recommendation, we know that that can be tricky. What we also do is we will work with people in the moment. So, you know, if you've got an idea of the types of questions and the way, we can take examples from that and work with you at the court to make sure that those questions are in line with that particular person's need. And it's not the same for everybody. You know, some people, tag questions become quite a big topic of conversation. Some people can manage tag questions, providing they're very, very short and they're not asked lots and lots of them. So our assessments now reports are very bespoke and very individualised to that person's need. Next slide. So in terms of who requires an intermediary, so HMCTS, their list of vulnerabilities is there, and I think the key thing, what we get at Triangle definitely is you might not tick any of them, and I think it touches, Sasha, on what you were saying about that necessity. And it's not about, oh, they've got a, you know, we can put a tick in a box. There is that other box that we can tick as well. And if it is around, you know what, they don't have any diagnosis, there's nothing really that we can see that's formal, but I know I'm struggling to communicate with this person, well, then that is enough, that other box, and that being able to say, look, it's just not working, we need some support, then, you know, that's always there. So I won't go through all them, but it was just to highlight that really. And that's me, that's intermediaries in a nutshell. Like I said, it was going to be whistle stop. Our LinkedIn is there, so if you want any, you know, further information, feel free to drop us a message on LinkedIn. Thank you.
Thank you, Kat. I told everybody at the beginning to put their questions into the chat box, but the chat box is disabled, so please use the Q&A box. There's some things in there already, so thank you very much. Please keep them coming, and I will pass over to Kat.
Hi everyone, thank you so much for letting me be part of this evening and talk about advocacy, which is my favourite subject. I think the word advocacy is quite confusing because it's used in different contexts, and it really does confuse everyone we work with. So every opportunity I've got to kind of explain what we do and how we work is a real opportunity for us. Next slide, please. You'll see from my presentation, it looks very different from a presentation you'll normally see, and that is deliberately because one of our main jobs as advocates is to provide information in easy read, and this is a typical easy read document that we would have translated or transferred from a legal document or something that social services had provided, and we formulate this kind of document where there's pictures and really simple words to explain what is going on to help those parents. So you'll see that every slide has got the same kind of easy read format, so that when you go away later on, you can see what that would look like if you wanted to do it yourselves. So just a little bit of information about Elfrida. We have been in operation in Islington, so we work predominantly in North London for over 100 years. And within that time, that has been supporting people with learning disabilities and gradually extending to people with neurodiversity as well. So at the moment, we provide every single type of advocacy known to man. So we have self-advocacy, peer advocacy, community advocacy, Care Act advocacy, and then our specialist parents advocacy service. We also use a co-production model, and what that means is that a lot of our staff that work with us have learning disabilities or autism or learning difficulties themselves. So when I need to talk to them about different things, I can use their opinions to get a really good understanding of whether I'm doing my job right and whether our advocates are doing it based on what they experience and what they can bring to it. Next slide, please. So the actual service that we work in, the specialist parenting one that we're talking about today, has been working in Islington for over a decade now. We're actually working in even more boroughs now. So I think it's up to about 19 in London, and we work in Slough and Kent. We are often asked to work in all different places around the country, but because of obviously timescales and the cost it would and the time it would take us to get there, we try and limit it to what's actually practical. So we have 5 part-time advocates working for the service, not including myself. A lot of them have between 15 to to 20 cases. We get an awful lot of referrals that come in, so we try and manage both their time and their emotional well-being, because it's a very, very difficult job, but also making sure that if we can't take a case, we've got someone else to pass it on to. I do take quite a lot of cases when I can, or when there's a particular case that fits my skill set. So at the moment I've got about 6 cases, but I do lots of other things, so I don't want to kind of spread my time a bit too thinly. So the way that we work as an organisation is the advocacy is spot purchased by the local authorities. So it has to be the children's team that will come to us and say, we have a parent who has any kind of vulnerability or learning disability. We really do think that they need an advocate. And it is solely reliant on that children's team to understand what advocacy is and to reach out to us before that parent will get support. There is no kind of, there used to be a specific learning disability that we required, but now, because the numbers of people coming through who have personality disorders and other vulnerabilities, we've opened the criteria to, if anybody needs us, we will support them. So anybody who is referred in, as long as there's nothing that conflicts with what we can do or what we can offer, we will support them. Next slide, please. So this is the spot purchase agreement, and I thought it was important to put it on there because it shows the things that we do have to do. So under the advocacy charter, which is what we work under as part of any kind of advocacy service, is we adhere to certain principles, and within those we tell local authorities that this is the bare minimum we're going to do for people. A lot of the local authorities will come to us and say, oh, we just want you to attend a meeting. And that is absolutely a pointless request, and it makes no difference to the clients. A lot of the work that we do with them is not about attending a meeting and explaining what's going on in that meeting. It's preparing them for the meeting and saying, this is what they're going to talk about. You don't need to worry. I'm going to be sitting next to you. And then afterwards we go, this is what was discussed and this is what's going to happen next. And most of the time our work is 2 or 3 days later, when that parent has thought about it and went, actually, I don't understand, and we have to go through it again. And we can go through it again and again. We can make easy reads. We don't know how long it's going to take for a parent to understand a certain topic because we don't know what their needs are. Some parents pick it up straight away. Sometimes it takes an awful lot of time. But the ticked boxes are the ones we absolutely do. The other things underneath, things we can absolutely help with, but we do understand that our service is very expensive. So if someone requests for us to do those additional things, we will do them, but we would normally signpost to someone else, like a support worker or another social worker, to do those things. Next slide, please. So we don't have an assessment like Danielle has, but we do have our own assessment that we have that just gives us a good idea when we meet a client about what their needs are. So it will give us an indication of whether they can remember things, whether they know who's involved with them, whether they can explain what their case is like, just so that we can then go back to the local authority and say, actually, I think this is going to take a little bit longer than what you think. And we can give them a little bit of evidence as to why our work is going to be a bit more intense than they'd hoped. The communication difficulties of that parent really do impact how much time we have to spend with them. So, for example, if we've got a parent who is very eloquent and presents in a way that they don't need an advocate, and when we meet with them, they break down, they're completely emotionally dysregulated, and they genuinely don't understand what's going on, we have to kind of explain to the local authority why our service is actually really beneficial. And sometimes it's really difficult to explain to them that how a parent presents is not always the same as what we see. And when they understand things, for example, if a social worker says, oh, well, they understood exactly what I was saying to them. No, that's what a parent presents as showing that they understand. But actually, when you ask them in depth, independently, they often don't have a clue about what's going on, but they're too embarrassed to say so. So we use a number of communication tools. We use EasyRead, we use communication cards, we'll use symbols and signs. We'll work with the parent in whatever format they prefer. Some of our parents, normally the ones that have personality disorders, tend to not like EasyRead at all, and that's absolutely fine. But that does mean that our verbal communication and our constant phone calls with them can mount up because they get really, really kind of distressed at not really understanding things, and they don't want to be seen to be using EasyRead. So verbal communication is the only way we can get that message across. Next slide, please. So in terms of the social workers that spot purchase the service, there is guidance in place for them, for all social workers to make reasonable adjustments for parents who they think has a communication need or a vulnerability. Unfortunately, it's guidance and it's not compulsory, and they are not obliged to do so. But we always refer people back to this exact document that's on there as guidance to say, what is the reasonable adjustment you've made then if you think that they don't need an advocate? We get a lot of parents coming directly to us that ask for advocacy, and we have to explain that because it's funded by the local authority, they're the ones that pay. And so we do need all the professionals around them to reach out to the local authority when they are refusing to pay, to say, everybody is in agreement here that the parent needs support. Please, can you go back to this document and put this reasonable adjustment in place to them? It really does vary massively at what point the social workers refer into our service. So they could refer in at the CIN child in need stage, or they could refer in right at the very last minute before a final hearing. And you'll see in the next couple of slides the difference in terms of what we have to do and what we don't need to do will really vary depending on the point that we're brought in. So the quicker we come in, the less work we have to do, the easier it is for the parent and the cheaper it is for the local authority. However, you'll see on the next slide that that isn't really how it works with them. So next slide, please. So at an early stage, so if we're involved at child in need or the very early stages of child protection, our job involves signposting to other organisations, attending meetings, explaining what's going on, and just generally establishing a really good relationship with the parent that is independent from everybody else, that they have got a really good separate person that they could go to, that they can trust, and we can help them with positive changes, parenting, and when they're told that they need to make some changes themselves, we can help them to find people to do that, or we can do that with them ourselves. So at this point, it's very, very easy, very low level work. Next slide, please. When you get a little bit further along, that's when the parent starts to panic a little bit, doesn't really understand what's going on, and tends to kind of fall out with the social worker, because the social worker and the parents are clearly then on very different pages. So we have to do a lot of explanation about what the parent currently understands about what's happening, and their understanding and their feelings towards why they're in this situation are often very complicated and very distressed. So we would go through all that with them, try and unpick their feelings, try and unpick what they understand. And then we will try and go through all the paperwork that they've been given. So that could be conference notes, it could be PLO letters, it could be literally anything that's sent through, to make sure that they understand every single part of it, and they're able to repeat it back to us to make sure that they're fully involved in the process. We will also at this point try to stabilise the relationship with the social worker, because often at that point they really hate the social worker, through no fault of the social worker's fault sometimes, but they just don't trust them. They don't really have a good word to say to them, and we really try and work on that relationship so that they can be in the same room and that they don't feel that they have to be separated from the social worker or feel bothered by them, because then that gives them the impression to other professionals that they won't work with people, and that's really not a good position for them to be in. At that stage, we will also help them find a solicitor, and then we will make a relationship with that solicitor and say, hi, we're the advocates, we're here to help, what do you need from us? We will also then attend any legal meetings that that solicitor and the client asks us to attend, so that the parent can get a good relationship going with the solicitor and that they are really comfortable understanding what they're saying. Next slide, please. Next slide, please. Thank you. At the late stage, this is like when we are halfway through proceedings or very near the end. This is just crisis management, to be perfectly honest. The parent is in an absolute distressed state at this point. So our job is to reassure them, make sure that we can explain everything that's going on and that they have some kind of voice in the process. Often we can go through paperwork with the solicitors and we can see gaps about what we've seen in meetings or what we've seen in paperwork that we know that the parent wouldn't have understood. So it's a job of kind of explaining to the social workers that actually you've said this in the paperwork, but how did you know that the parent understood that? What did you do to make sure that the parent was involved in this? And we can kind of help build the case for the parent to say that actually they haven't really been given a good chance here to actually parent their children. So we often spend a lot of time with the solicitor and the barrister going through what we understand about the parents' communication needs and what we think the barrister and the solicitor would be really helpful for them to know. We will also support them up to court all the way through to the final hearing, even if there is an intermediary. Our job is very different for the intermediaries. You'll see in the next slide. We work together with intermediaries. We are not in some kind of competition with them. We would do very different roles, and it's really, really important that we work with them. So just a little bit more about the final hearing. When we get to that point, we need to make sure that the parent understands the final decision that's been made by the judge, and we will give them an easy read version of it if the intermediary hasn't done that. And then we will make sure we do a final meeting with them and signpost them onto other organisations, because this is the most critical point for a parent, where they're just left to kind of dangle off the edge of a cliff where everybody's left them. They're very likely not likely to have their children with them, and so their self-esteem, their confidence and their mental health is really, really challenged at this point. So we make sure that that parent is fully supported before we would then close the case with them. Next slide, please. Next slide, please. Thank you. So in terms of our work, that's fine. We work under a trauma-informed practice, because, like I said earlier, a lot of our parents are working either at the hyperarousal stage or the hypoarousal stage, and they're either disengaged completely and don't want to be involved in anything, or they are so hyper and unable to engage with the professionals that they present as either not interested or they present as really difficult and challenging. And I think it's very difficult for a lot of professionals to really understand why parents react in the way they do. So it's our job to help the parent manage those feelings and explain to them why the way they're behaving can be misconstrued by the professionals. So we would then talk to the professionals and say, actually, this parent is really, really stressed or traumatized, and I think maybe your approach might need to change a little bit. So it's a lot of kind of working out the emotional state of that parent and helping them through. Next slide, please. So many parents that we're working with have been through lots of trauma themselves. They've had lots of negative experiences and they've got lots of generational trauma. This really impacts their work with the social workers, because they've got years and years of not trusting them, having lots of resentment towards them, and then their parents being resentful and not wanting them involved. And it's just like a real challenge to try and unpick where that relationship could improve and what we could do to help it. So we really try and encourage social workers to be really open and honest with clients, be really appreciative of their situations and not make any judgments about them, and really use us to understand that parent's needs, because we literally spend so much time with our parents. We speak to them so often, we attend so many meetings with them, that we know everything about them. We know what their triggers are, we know when they're likely to say something or do something, and so our role is really important to help make sure that every other professional knows that as well. Next slide, please. So just to end up, the work we do with intermediaries is really, really important. So because we are not involved in being appointed by the courts, we're appointed by social services. The legal teams have us there whether they really like it or not. If a parent feels that they have a really good relationship with us and they would like us there, we will be at any meeting that they want. But our job is so different. We have no power to stand up in the court and say anything. We have no power to be involved in any meetings, to make any suggestions. We're literally just there to make sure that the parent is emotionally engaged, is not likely to be dysregulated, and if they decide that they need to leave for any reason, we will take them out of that courtroom, kind of regulate their emotions and then bring them back in. So when we're working with intermediaries, we take a real step back when we know that they're there. We will offer support about our knowledge of the parent when we can, and we will help with the outside of court area and just be there for the parent to feel confident. But we really make sure we try and engage the parent with the intermediary so they can do their work together and make sure that they will communicate with them, and then we back off. And as soon as court is over, we take the case back up again. So we don't get involved in any of the things that the intermediary do at all. Most of the things that we do, as you see at the bottom, is to try and help parents get through security, because that's often the very worst part for them, and it sets them up in a really bad way for the day. So once we've got through security, we can kind of relax and hand them over to the intermediary. Next slide, please. Alongside that, we help the intermediary with the communication. If we know something about the parent that the intermediary may not, we'll try and help explain why a parent's acting that way or communicating in that way. And we will make sure that we listen to what the debrief was so that we can then continue that work with the client afterwards. Next slide, please. So we are often asked by the judge to fill in for an intermediary, or if we are there in the courtroom and there isn't one, we're often told, well, the advocate can do that work. And we make it really, really clear that we cannot do that work. We need to make sure that both the intermediaries and the advocates are there working with that client together. So at no point will you ever hear us say, yes, of course we can do that work. We'll ask for another advocate for maybe another client, but we would never say we can step in and do that work with them. It's really important that the intermediary can help them with the communication and do all the work that they do, and we help with the emotional side of things. Next slide, please. So a lot of things I've just spoken about, we've covered in this section. So we take instructions from our client at what we do at every stage, whereas the intermediaries will work independently for the court. We are there for the clients. We don't try to encourage them to do anything other than try and work with the intermediary, and we are there just to support them with whatever they need emotionally at that point. We do provide a communication assessment. Sorry, we don't provide a communication assessment for them, and we don't often read the intermediaries, but we do try and work with the intermediary as soon as we know that they're involved to reach out to them and kind of make sure that there's a whole team working alongside the clients so that everyone's working together with them. Next slide, please. There we go, end of that. Thank you very much.
Thank you so much to all of our speakers. We've got a couple of questions which we're going to come on to. When I was initially thinking about this topic, I was thinking about it through the lens of my own experience, obviously, which was always that I felt myself fighting with the court when I was seeking an intermediary within the proceedings. Whereas if my case involved an advocate, they were already in place by the time the client got to me. And partly that's because of the mechanism that Kat has explained, that particularly with the Elfrida Society, that they are almost inevitably involved by the local authority at an earlier stage, sometimes even pre-proceedings, to support someone during the course of the proceedings. But when I looked at the President's guidance, the introductory sentence says, in any case in which an application is made for a cognitive assessment or for an intermediary or lay advocate assessment, and on it goes. And it had honestly never occurred to me that we could make a lay advocate application once within proceedings. Just had never occurred to me. And because I was looking at it through that lens, I had sort of cynically noted that an intermediary whose appointments seemed to me to be being tightened by the courts had come from the HMCTS budget. Now, we've had a question about that, who would pay for an intermediary? And the answer is HMCTS. They're treated the same as an interpreter in that sense. Whereas the judges in those same cases who'd been effectively giving me a hard time about having an intermediary had welcomed the involvement of a lay advocate. And as Kat was just explaining, almost saying, well, you've got an advocate, they'll do, won't they? Why do you need an intermediary as well? And the reason that I wanted to do this seminar is because I was finding it hard to answer that question. And so Kat and Danielle, between them, have given us the answers to those questions tonight about how we can explain to the court why, in the right cases, in fact, our clients might well need one or other, and sometimes both. Now, in terms of a court application for a lay advocate, in fact, there's clear case law that I just had never seen that says they can easily be funded by HMCTS in just the same way as an intermediary or an interpreter can be. So now I know that, it might be interesting to see if the same pushback follows, because I can think of a lot of vulnerable clients I've had over the years in all types of proceedings for whom an intermediary probably wouldn't have been appropriate, but certainly would have benefited hugely from a lay advocate's assistance. And I wonder if we can make more use of that in appropriate cases as well. Another question that we've had is really for Danielle, and in terms of the communication specifically, how is it impacted when you've also got an interpreter involved?
Yeah, it's really tricky. Being honest, it's really, really tricky. But I've done lots of interpreter cases actually, and we've done lots of learning at Triangle around that. And what we've tried to do is think about that much more at assessment level. So what we do at assessment is we tailor that assessment to think, right, okay, what's going to happen in court and how is this going to be played out? So we do particular assessment tasks looking at English into another language, then that language back into English. And we look at how much longer that takes. And we look at that level of simplification that might be needed, but also look at particular words that don't necessarily translate across from the English language into the language that you're going into, and some of those differences. A key one that springs to mind for me working with an interpreter is every time the local authority was mentioned, the interpreter was saying police, and they were interpreting it as the police. And you can imagine that vulnerable person was just absolutely terrified by, why were the police involved now? What does this mean? So it's about doing a lot of work before we get to hearings, actually. And one of the key things is trying to secure the same interpreter, and getting those relationships and getting all those sort of nuances in the languages, trying to get them ironed out before we actually get to hearings. And then it does take just a lot longer. Some of the things that we've done is that we've had, for particular types of evidence that is quite complex, that where we might need to simplify more, so we've asked for CVP, and we've done it from a different room so that at least it's not disruptive to everybody else trying to explain some of those concepts. So those are some of the things that we do, and I could probably talk about interpreters all night, but I won't. But yeah, it is tricky. But I think we are learning as intermediaries, and hopefully, certainly from the interpreters that I've worked with, they're learning as well. And it's about that collaborative approach and trying to make sure that you have, as an intermediary, you also get some time with the interpreter to understand from their point of view as well what their understanding of that vulnerable person's communication is, even just in their own language, can be really quite helpful. So for me, it's around collaboration, definitely, to make it better. But yes, it does add an extra barrier and an extra layer of difficulty.
Thank you. And I think another takeaway from what you've just said is that we all need, wherever we can, to absolutely maximise the continuity. If anybody is vulnerable, for any reason, solicitor, barrister, interpreter, intermediary, advocate, as many of the same people as we can keep involved with that client, the better their engagement is going to be.
Absolutely.
Okay, Heidi.
Yes, thinking of keeping everybody the same on board, Sasha or Danielle, I think this is really for you both. Do you think it's better to have a ground rules hearing tagged on, like you said at the start, before we start a fact-finding hearing, or a final hearing? Or do you think it's more effective to have it separately, or does it depend? I want to hear about this, please. I have a view.
I think, unhelpfully as ever, it depends. I think it depends on when, first of all, you actually had your assessment with the intermediary. So it might be that actually there were questions about the client's possible engagement really quite early on in proceedings. But it might be that sometimes these things, clients can become very vulnerable almost overnight, and sort of certain things come out and you think, hang on, I think we all need to have a little think about this and get an assessment now. But assuming you have the benefit of some time, I think actually it's quite helpful to have a separate ground rules hearing, almost kind of tacking it onto PTR really, rather than tacking it onto the main event. Because even for a client who's not vulnerable in this sense, something like a fact-finding or final hearing is very stressful and very emotional in any event. And the one thing that clients really want is just some certainty about what it's all going to be. They know you can't predict the outcome, but they want to know, so what time am I getting there? What are they going to be discussing? Who's talking first? And the simplest questions, am I allowed to eat food? Can I go and have water? These questions come out from clients who aren't vulnerable. And so I think expecting clients who are to then also you not be able to give them that clarity ahead of a hearing, if they are particularly vulnerable, to say, and this is how the questions are going to be asked to you. These are the measures that are going to be in place. I think you can build up, and particularly for clients who I've had who've been very anxious and that's been their vulnerability, it just causes a sort of huge emotional storm before the sort of main event hearing, because they're so worried about how any of this is even going to happen, that even if it all, you get every order that you seek at the start, I'm not sure then that they have enough time to sort of turn around and go, okay, that helps. Right now I can give my best evidence. I wonder if we're asking too much of our most vulnerable clients in that moment. So I think where it's possible to have, tack it onto PTR or have a separate one, the better.
I think if I can just add to that, Heidi, because for me in practice, one of the best ways I think is yes, definitely have it beforehand in relation to participation and how we're going to manage that. But actually, I'm a real sort of champion for let's have another one just before a vulnerable person gives evidence, because actually, if we've got, for example, a 10-day fact find and they're not going to give evidence till about day 7, the amount that I've learned about that person in those days, if I've assisted them through participation, is huge. And actually, some of the recommendations that I made initially from that very first assessment either might not be relevant anymore, or actually I might need to make some more, having now seen them in the courtroom and in that environment. So yeah, totally agree, but I'm a real sort of champion for let's have another one just before they give evidence to make sure we're actually doing what we need to do and not basing it on an assessment that was potentially done 3 months ago and now I've got all this new information. So yeah, just
I totally agree, because also people, we do a human job. It is a human business, and clients are not linear. They don't do things you necessarily predict, and particularly with vulnerable clients, and if it's vulnerability in relation to mental health particularly, that can change day by day, week to week, month to month, and very different things, exactly as you say, can be different triggers that you wouldn't necessarily have predicted. And absolutely. So absolutely, sometimes you really just need an updating one. And typically when you have an assessment, what I've found with more proactive judges or more familiar judges with this is they grant you the assessment and they grant you the intermediary for a particular event, and then once that sort of time is in effect expired, then if you want another one, then it's encouraging you to go back and say, look, we need an update here because there's more work to be done and the needs might have changed.
Yeah, and we will often produce addendums to our report, having worked with a vulnerable person, after a couple of days, you're all, as an intermediary, you are always assessing. So if there is big differences, you will highlight that, and whether that's just through the barrister and it's verbally, or whether or not we produce an addendum to that report.
I think what I'm learning from this is that really thinking about the court timetable is all of this. It takes time, and I think when we do listings, we're always pushing, asking for more time, but for me, this has equipped me with so much more to be able to explain to a judge and justify why I'm asking for a longer listing, to enable all of these things to happen and actually really explain it and tailor it. And I know, Danielle, that you said there was a lot of focus on questions and asking, and that's in the gateway. But from my perspective, that's a lot of my job. And I personally think having a PTR before with a lot of time would really help me understand that question role. Thank you very much. I think we've just got time for one more question.
Yes, we've had a question come in, which Danielle, you just touched on a little bit. The question is, would you need to have an updated assessment to justify continuous use of an intermediary? So the short answer is no, not necessarily. But the court might be saying, oh, it's been a long time since that assessment. You've just produced a school report that says they're doing brilliantly. Do we still need an intermediary? So you might do an assessment for that reason. But also we've just heard from Danielle that in fact the intermediary might be suggesting themselves that there's an update. Presumably that would be, sadly, more likely if there are more needs than were originally identified at the beginning. So it might not be a great thing for your client, but yes, the short answer there can be.
Yeah.
Does anybody have anything they want to add to that answer?
No, I agree, and I think there's almost sort of follows on slightly to I think what was asked below is, are there gaps in current court practice guidance? Is it case by case? I think absolutely more awareness about this is helpful, because if everyone, it's sort of, you're taking up more time, but to save time overall. And so I think where we're all kind of working towards that, and with more awareness in that respect, I think we can all be better efficient. And absolutely, I think following this Court of Appeal guidance, it would be great to have sort of an updating practice note with some more step-by-step guidance about how this process could be effectively managed, also to give judges confidence about when to grant one, when not to grant one, and how best to timetable it, because they're all very busy. And, there's a lot of courts around England and Wales, and they're trying to work out the best way to do this. I think actually some more cohesive guidance with at least some guidelines going, if it's like this, try this. If it's like this might help, could be quite useful.
Well, I think we've got the working group here to put together that guidance. It was really helpful.
Yes, thank you all so much for your time tonight. We are going to follow up with everybody with the slides and the recording next week. So thank you again for joining, to our speakers, to everyone who's helped me put it together. Thank you very much.